Welcome back to the deep dive. Usually when we talk about the government, we're talking about the loud stuff.
Right.
We're talking about um, taxes, the wars, the scandals you see on the front page, the shouting matches in Congress.
Yeah.
But today, we're doing something, well, something very different. We're going to look at the silence,
The silence, that's an interesting way to put it.
the invisible architecture.
Yeah.
I was reading through this massive stack of legal doctrines you sent over. We're talking privileges and immunities, the takings clause, prohibited legislation, and it really hit me.
Mm.
These aren't just dry laws in some dusty old book. This is the operating system. It's the code running in the background of our society that decides if you actually own your house or if you can, work in another state.
Or if the government can just change the rules of the game on you.
Exactly. To make you a criminal for something you did yesterday.
That's the perfect way to frame it. I mean, everyone argues about the user interface, which is politics, but very few people ever really look at the kernel code.
And that's what we're doing.
And that's exactly what we're doing today. We're looking at the specific constitutional guardrails that define that friction point between state power and your individual reality.
And it is friction. That is the mission today. We are going to decode this rule book, and we are not going to do it with impenetrable legalese.
No, please no.
We're going to do it with shrimp, elk, beachfront condos, and apple trees. By the end of this deep dive, I want to know, where does their power end, and where do my rights actually begin?
It's a messy line, but, at the end of the day, it's the only line that matters. These doctrines are the invisible guardrails of democracy. You might not see them when you're driving down the highway of life,
Uh-huh.
but if they weren't there, or if they were moved even an inch, your daily existence would look drastically different.
So let's jump right in with something that feels very, very modern. I mean, we live in a remote work world now. People are mobile.
More than ever.
I pack up my laptop. I moved from New York to Florida or, I don't know, Texas. I just assume, because it's all the United States of America, that nothing really changes.
Yeah.
I'm an American in New York. I'm an American in Texas. But looking at this research, that's not entirely true, is it?
Not entirely, no. You're entering the realm of Article 4, Section 2 of the Constitution. It's called the Privileges and Immunities Clause.
Okay.
In the legal world, though, we often call this the Comity Clause.
Comity, that's Comity, which basically means, what, playing nice?
Essentially, yes. It is the let's all get along clause for the states. You really have to remember the context here.
Before the Constitution.
Right. Before the Constitution, under the Articles of Confederation, the states were acting like, independent little kingdoms. They were charging tariffs on each other's goods, banning outsiders from working.
Act like rivals.
Complete rivals. The Founding Fathers realized that if every state continued to act like a foreign nation to its neighbors, the Union would collapse in, a week. So Article 4 is your visitor's pass. It prevents a state from discriminating against citizens of other states.
Okay, so I have this pass. I walk into a new state. Am I bulletproof? Can I do everything a local can do? No questions asked.
No. And this is the first trap everyone falls into. The visitor's pass has some very specific fine print. First, it only covers citizens.
Which I assume means me, a person.
You, the biological human. Crucially, it does not cover corporations.
Oh, that's a big deal.
It's a huge deal. And it does not cover non-citizens, or aliens, as it's termed in the legal text. So if you are a Delaware corporation doing business in California, you don't automatically have these Article 4 protections. You're a legal fiction. You're not a citizen in this context.
That's a massive distinction, given how much corporate business happens across state lines.
Yeah.
But let's stick to the human element for now. I'm a human. I cross the border. What exactly is protected? Because I feel like if I go to a state park in another state, they always charge me more for camping. Is that unconstitutional?
And that brings us to the fundamental rights test. This is where the rubber really meets the road.
Okay.
The Constitution only protects things that are considered essential to the concept of being a citizen in a single unified nation. We're talking about things like your economic livelihood, your access to the courts, the ability to buy and sell land.
So the big stuff.
The big stuff. We are not talking about cheap camping or recreational hobbies.
This is where we have to talk about the shrimp versus elk example from the notes. I mean, it's the perfect illustration of this. And honestly, it helps clarify why some things are okay and others just, aren't.
It really is the best way to understand this distinction between a livelihood and a hobby.
Okay, lay it out. Scenario A. The commercial shrimper.
All right, so this is based on a real case, Toomer v. Witzel, from back in 1948. Imagine you're a commercial shrimper. You're based in Georgia, and this is how you make your living, catching shrimp.
Right, putting food on the table.
Exactly. You drift into South Carolina waters to ply your trade. Now, South Carolina looks at all these out-of-staters competing with their local guys and says, wait a minute, we don't like this competition.
If they decide to rig the game.
They absolutely rig the game. They pass a law. If you are a South Carolina resident, a license for your shrimp boat is, say, $25.
Okay, seems reasonable.
But if you are a non-resident, the license is $2,500.
Whoa, that's 100 times more. That's not a fee, that's a wall. It's a tariff, a trade war.
Precisely. And the Supreme Court shut it down immediately. They said shrimping is a livelihood. It's how these men feed their families. In a national economy, you have a fundamental right to do business across state lines on a roughly equal footing. By charging that exorbitant fee, South Carolina was effectively banning them from the market solely because of where they lived.
And that violates the Comedy Clause.
That's a clear violation.
Okay, so if it's my job, I'm protected. Now let's flip it. Let's look at scenario B, the elk hunter.
Right. This is from another case, Baldwin v. Fish and Game Commission from 1978. So you have a group of guys, they go to Montana to hunt elk, but, and this is the key, they aren't professional hunters selling meat. They're recreational hunters.
They're there for the sport, the vacation.
Exactly. They're there for the hobby. Montana says, welcome, glad to have you. Residents pay roughly $9 for an elk license, you guys. You pay $225.
Okay, again, a massive markup. It's nearly the same ratio as the shrimp case, so I assume the court struck this one down too.
Actually, the result was the exact opposite. The court said, pay up.
Wait, what? That feels inconsistent. Why is the shrimper protected, but the hunter gets fleeced?
Because elk hunting, in this specific context, is a sport. It's a recreational activity. It is not fundamental to your existence or to your rights as a citizen.
Ah, so it's not about making a living.
It's not. The court's logic was, look, Montana spends its own tax dollars managing the elk herds, preserving the habitat, paying the rangers. They are allowed to say, this is our resource, we subsidized it with our taxes, and since you don't pay taxes here, you have to pay a premium to access our playground.
That is a very, very sharp dividing line. So just to play devil's advocate, if I'm killing the elk to sell the meat to survive, maybe then I have a case.
Maybe. I mean, if you could prove it was your commercial livelihood, the entire analysis might shift. But as a tourist, no chance. You pay the tourist tax.
What about information? This one in the stack, this one scared me a bit.
Yeah.
McBurney v. Young. It's about FOIA, the Freedom of Information Act.
Yes. This case really, really surprises people.
I always assumed freedom of information was, free.
Yeah.
For everyone. If I want to see public records, they're public. End of story.
The Supreme Court disagreed. Virginia had a law on the books saying only Virginia citizens could use their state Freedom of Information Act to request public records. An out-of-state lawyer tried to get records related to a case he was working on, and the state just slammed the door.
So he sued.
He sued, saying, hey, Article 4, you can't discriminate against me just because I happen to live in Delaware.
And the court upheld the discrimination.
They did, unanimously. The court's logic was fascinating, actually. They said that FOIA is a tool for political accountability. It's a mechanism for constituents to check their government.
Okay.
If you don't live there, you aren't a constituent. You don't vote for those officials. Therefore, you have no fundamental right to audit a government you don't belong to.
That seems incredibly dangerous. I mean, what if I'm an investigative journalist from New York looking into corruption in Virginia? I'm effectively blocked.
Yes, under that state statute, you would be. Now, states can choose to open their records to everyone, and many do, but the Constitution does not force them to open their books to non-citizens.
Wow, that really limits the visitor's pass. It's strictly for economic survival and, basic legal protection, like being able to access the courts. It's not an all-access pass to the state's resources or data.
That's a perfect summary. And even when a fundamental right is involved, let's go back to jobs. The state can still discriminate if they have what's called a substantial justification.
This sounds like the we have a good reason loophole.
It is a loophole, but it's a very narrow one. It has to be a very good reason. This is the substantial justification test. The state has to prove two things, and they have to prove them with evidence.
Okay, what are they?
One, they have to show that the out-of-staters are the specific cause of a particular problem the state is facing. Not just a general problem, but that they are the source of the harm.
And the second thing?
Two, that the discrimination is closely tailored to fix that specific problem. It can't be a sledgehammer when you need a scalpel.
Let's talk about the Alaska case you mentioned in the notes. Hicklin v. Orbeck. That seems to fit right in here.
It's a classic example of a state trying to hoard its wealth. It was the 1970s. Alaska had the pipeline boom. Money was flowing, jobs were everywhere.
The state was rich.
Very. And they passed a law called Alaska Hire. Basically, it said that all jobs related to oil and gas in the state had to go to Alaska residents first. Out-of-staters could only get jobs if no qualified Alaskan was available.
Which is great politics, right?
Yeah.
Jobs for Alaskans. I can see a governor running on that.
Great politics, terrible law. The Supreme Court struck it down. They said you can't just ring-fence your economy.
So they failed the test.
They failed both parts. First, Alaska couldn't prove that out-of-state workers were the cause of high unemployment for Alaskans. In fact, there was evidence that there weren't enough locals with the skills to fill all the jobs.
So they failed prong one. What about prong two?
They failed that too. The law was way too broad. It applied to every single job, from engineers to janitors, without any analysis of whether certain positions actually had a shortage of local applicants. It wasn't tailored at all.
And the court made a point about something called the market participant exception, saying it doesn't apply here. What's that about?
Right. So in other areas of law, there's a doctrine that says when the state acts like a business, like when it owns a cement plant and sells cement, it can favor its own citizens as customers.
What?
But the court here said that doesn't work for the Privileges and Immunities Clause. When it comes to the fundamental right to earn a living, the state can't just act like a private business choosing its favored employees. It's acting as a sovereign regulator, and the rules are different.
So that's the horizontal protection, state to state. Let's pivot now to the vertical protection, the one between you and the federal government, the 14th Amendment. It also has a privileges or immunities clause. It sounds the same, is it?
Ah, yes. Section 2 of our deep dive, the story of the paper tiger.
Why do you call it a paper tiger? I mean, the 14th Amendment is the heavyweight champion of the Constitution. Equal protection, due process. Those are the heavy hitters that changed America.
They are, absolutely. But specifically, the Privileges or Immunities Clause of the 14th Amendment was, well, it was murdered in the crib.
Murdered in the crib.
It reads, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States." It sounds incredibly powerful.
It sounds like it should protect everything. My right to speak, to work, to worship.
It should have. That was probably the intent of its authors. But it doesn't. And that goes back to one of the most infamous decisions in Supreme Court history, the Slaughterhouse Cases of 1873.
I love that name. It sounds like a horror movie, but it was actually about
Butchers, right?
literally butchers in New Orleans.
Yeah.
But it became a horror movie for civil rights lawyers for the next century.
So set the scene. What happened?
Okay, so after the Civil War, we have this brand new amendment, the 14th, and it's meant to protect the rights of newly freed slaves and really all citizens from state tyranny. The federal government is finally stepping in to protect basic rights.
And Louisiana passes a law about slaughterhouses. Right. For public health reasons, they created a monopoly. They said all butchering in New Orleans had to happen at one specific state-chartered slaughterhouse.
So all the independent butchers were basically put out of business.
Exactly. They sued. They argued that this monopoly violated their privilege or immunity to practice their trade to earn a living. They said the 14th Amendment protects this fundamental right.
It sounds like a reasonable argument.
It does. But the court, in a very narrow 5-4 decision, essentially nullified the clause. They were terrified of upsetting the balance of federalism, of giving the federal government too much power over the states.
So how did they get around the plain text?
They created a bizarre distinction. They said there are two types of citizenship: state citizenship and national citizenship. They ruled that this clause only protects the privileges of national citizenship.
And things like free speech or the right to work?
The court said those are privileges of state citizenship. So the 14th Amendment's Privileges or Immunities Clause doesn't protect them from state action. They effectively said the clause was meaningless for protecting basic rights.
So what on earth is a national right if it's not free speech?
It ends up being this very weird, eclectic, and mostly useless list. The right to travel to Washington, D.C. to petition Congress, the right to protection on the high seas,
Okay.
the right to enter public lands, the right to be protected while in the custody of a U.S. Marshal. And that's about it.
That's it. That's the entire list.
That's basically it. For over 100 years, lawyers have tried to use this clause to protect actual meaningful rights like the right to work or freedom of speech. And the courts just point back to Slaughterhouse and say, nope, Wrong clause, go look at due process or equal protection.
So the real work of protecting rights had to be done through other parts of the 14th Amendment.
Exactly. The due process clause ended up doing all the heavy lifting that the privileges or immunities clause was probably designed to do.
But there is one survivor, one actual tangible right that still lives in this clause and matters to regular people today.
The right to travel. And this is crucial for anyone listening who thinks about moving from one state to another.
This brings us to Sines v. Roe. This is a relatively modern case, 1999.
This case revived the clause for one specific but very important purpose. The facts are pretty simple. California was tired of people moving there, they thought, for the generous welfare benefits.
They felt like they were becoming a magnet for the poor.
Right, so they passed a law that said if you move to California for the first year you live here, you only get the welfare amount you would have received in the state you came from.
So if I move from Mississippi, which has very low benefits, to California, which has high benefits and, much higher rent, California says, we aren't paying you our rate yet. Here's your Mississippi level check. Wait a year.
Exactly. They were creating a two-tier system of citizenship for new residents, and the Supreme Court said, absolutely unconstitutional, and they based it on the 14th Amendment's privileges or immunities clause.
So they breathed life back into the paper tiger.
For this one purpose, yes. They said, you have a fundamental right as a U.S. citizen to pack up your life and move to a new state. And here is the key. Once you land there and decide to stay, you are a citizen of that state instantly.
Instant citizenship.
Instant. There is no probationary period for citizenship. You don't have to earn your stripes. You show up, you intend to stay, you are a Californian. Period. The state cannot treat you as a second-class citizen or penalize you for your decision to move.
That's a really powerful concept. It prevents kind of caste system where new arrivals are treated differently than the old guard.
It does. It ensures that we remain one nation, not a collection of 50 little tribes who are hostile to newcomers.
Okay, so let's do a quick recap here. This is our first big checkpoint, the privileges stack.
Let's do it.
So Article 4, the comity clause, that's the workhorse. That's your visitor's pass. It lets you work in other states without getting price gouged on licenses. That's the shrimp rule.
Right, for fundamental rights.
But it doesn't help you with hobbies. That's the elk rule. And it doesn't guarantee you access to a state's public records.
Perfect.
And then there's the 14th Amendment version, which was mostly dormant after Slaughterhouse, but it has one very important job. It protects your right to move permanently and become a full-fledged citizen of your new home instantly. No waiting period.
The visitor's pass and the moving van.